Hello, this is James Hutchinson. I can see that the numbers of attendees are now kind of stabilising, not shooting up as they were before, so I think it's about time we begin now. I think this was probably advertised for an hour or so. I think we'll actually probably be a bit quicker than that, probably more like a half an hour webinar today. With some opportunity for questions. If you'd like to ask any questions, either you can email them in, or if you have a look on the little toolbar application that you should be able to see, there should be a box on there for asking questions. Please feel free to do that as we go along. I'll either answer some of them at the end, or if there are a lot, we'll probably take them all away, and I'll circulate answers to those questions if I can to everyone. So just a quick introduction. I'm James Hutchinson. I lead the corporate team at Beal & Co. My team deals with procurement related issues, including front-end queries and procurement challenges. And today, what I thought would be useful for the webinar or the seminar is to give you a brief refresher of the Public Contracts Regulations 2015. These govern the purchase of goods, works or services by public sector bodies. The regulations are 128 pages long, supported by numerous policy notes. So I'm going to summarise the key issues. You'll be pleased to know I'm not going to be going through the regulations themselves in any details. The main objectives of today are really to help you identify when the procurement regulations apply, to monitor that the contracting authority is complying with the many obligations that an authority has, so that you know what to do if you want to challenge a procurement award. And I think we're seeing an increase in procurement challenges at the moment, and to understand, if it is at all possible, what the likely impact of Brexit will be on procurement. So, public procurement in England, Wales and Northern Ireland is governed by the Public Contracts Regulations 2015 and the Utilities Contracts Regulations 2016. The regulations themselves don't apply in Scotland, but there are separate but very similar regulations which have been adopted there. Today I'm going to focus on the public contract regulations. You should always be able to tell which regulations apply to your procurement exercise by looking at the OJU notice, the contract notice, which sets out the basic information about the contract. You know, what services are being procured, who the contracting authority is, all that kind of information should say on there which regulations apply. And it's important that you check that, and it's important that you follow the procedures under the correct regulations. So the regulations place some general obligations on authorities, and they must ensure that the procurement process is run with transparency. So all of the authorities' decisions should be completely transparent and accountable. You've got to remember that all the decisions that a public body makes could be subject to Freedom of Information Act requests, and we'll come on to that a little bit later. They need to be accountable, they need to document it, it needs to be evidence-based when they make decisions. Most authorities are getting better at doing this, and they're keeping an audit trail of those decisions. Equal treatment: all bidders must be treated equally, irrespective of their country of origin, whether they have an existing relationship with the authority or are the current incumbents on a project. Just because you are the incumbents on a huge contract that's been going on for the last 4 or 5 years shouldn't put you at a advantage, though we all know it can put you at a competitive advantage or disadvantage depending on how the project has gone to date. And non-discrimination: the authority is not allowed to discriminate against the bidders on subjective grounds. They must follow the objective criteria excuse me, usually set out in the invitation to tender. So the regulations only bite where an entity that is a contracting authority for the purposes of the regulations awards what is known as a public contract. And the definition of a contracting authority is pretty wide. It includes what you might think of as obvious parties, so central government departments, local authorities, police and fire authorities, NHS trusts, and various non-departmental government agencies, for example, the Financial Conduct Authority, the Information Commissioner's Office, etc. A long list of these named contracting authorities is set out in Schedule 1 of the regulations. So this is slightly different to the utilities regulations, where there isn't a list of who is a contracting authority under the utilities regs. In addition to those contracting authorities listed in Schedule 1, other bodies governed by public law can fall within the remit of the regulations if they have certain characteristics. That is, they are established for the specific purpose of meeting needs in the general interest, so they don't have an industrial or commercial character. They have legal personality, and they have any of the following characteristics. So it's not all of them, it's just any. So they're financed for the most part by the state or by some other public body. They're subject to management supervision by those authorities or bodies, or they have an administrative, managerial, supervisory board, more than half of whose members are appointed by the state. So you can see that if, for example, you had a nationalised industry, or the government took a more than 50% interest in a commercial business. The regulations only apply to contracts with a value of the amounts set out in the following table. So these are called the thresholds, and as you can see, there are different thresholds for different types of procurement, supplies, services, works. The thresholds on the screen are those that apply from the 1st of January 2018. They're pretty much regularly updated every couple of years. A few days ago, on the 31st of October, the European Commission has published revised procurement thresholds in the office of in the OJEU, and these apply from the 1st of January 2020. So in a month and a half's time. Probably of most important to you on the webinar are the increases in services to central government authorities. That's gone up to €139,000. For other public sector bodies, €214,000, and for works to €5.35 million. The Commission is going to calculate the values of those thresholds in sterling shortly, because they set the exchange rate on a certain day. But actually, if you look at what the figures are, those increases are relatively small. They're not much different from the figures that you see on the screen at the moment, and that's presumably because inflation has been relatively low. So what are the obligations on an authority if a contract is found to be subject to the 2015 regs? If a contract falls within that, then the authority must publish a notice known as an OJEU or contract notice in the official journal of the European Union. So that's OJEU that I mentioned before. The notice has to take a standard form. There is a kind of a set out template for doing it, and it must follow one of the 5 standard award procedures. So that's the open, the restrictive, the competitive procedure with negotiation, the competitive dialogue, or the innovation partnership. I don't really propose to go through each of those procedures today. We could spend half an hour looking at those. I've got a very short 2-page note on them, which what I'll suggest I'll do is if you stay on the webinar and you're interested, I'll send around the slides, and I'll also send around that note. And I think there's probably a couple of other notes that I'll mention, which I'll put together in a little PDF and I'll email out to everyone. Each procedure includes a number of stages. They're slightly subjective, or they're slightly dependent on which of the procedures you're going down. But really, to summarise them, there is the advertisement. There might be pre-qualification, other than for the open procedure. You might have invitation to tender, the right to participate in the dialogue negotiation. There'll be submission of tenders, the evaluation of bids, an award decision, a standstill, and then hopefully if you get through all of that, you have the completion of the contract, so the signature of the contract when all the parties enter into it. In September 2016, the government published revised statutory guidance on the process of supplier selection and the standard selection questionnaire, known as an SQ, to be used in place of the existing standard PQQ. And then on certain procedures, the authority will usually send out an SQ seeking information about the bidders. The SQ should set out the eligibility and selection criteria and methodology used to assess whether bidders are qualified to bid and shortlist candidates prior to the tender stage. On receipt of the bidders' SQs, the authority should apply its pre-qualification criteria to the responses and select those suppliers it will invite to submit tenders. The authority must disqualify any bidder it knows has been convicted of involvement in, and there's a whole list, but it's things like crime, corruption, bribery, fraud, terrorism, child labour, human trafficking, and non-payment of taxes or social security contributions. An authority must exclude a bidder to which any of those mandatory grounds apply, but can decide not to exclude on an exceptional basis. These are overriding reasons relating to the public interest, such as public health or protection of the environment. In my experience of tenders, I've never actually seen the mandatory grounds used to mandatory grounds overridden because of one of these exceptional bases. So I think it's got to be very few and far between. The regulations can also, they also contain additional grounds for what are called discretionary grounds for exclusion. And these include things like grave professional misconduct that renders the bidder's integrity questionable, pretty subjective there, collusion between bidders aimed at distorting competition, where the bidder has shown significant or persistent deficiencies in the performance of a subjective requirement under a prior public contract, a contract with a contracting entity, or a concession contract that led to early termination of the project and the contract, damages, or other comparable sanctions. And in my mind, the last of those list of discretionary grounds for exclusion, that's the exclusion for prior poor performance, is the most dangerous and probably most interesting for lawyers. Poor performance on a contract for a relatively small public sector client could really result in a bidder being disqualified from bidding on a much larger government contract. It sort of emphasizes to me, and I've seen this in a couple of situations, that you really do need to robustly manage your existing contracts, so that if a contract is terminated early, so we're talking about public contracts here, or you're penalised for performance management issues or breach of an SLA, what you want to make sure is that there's minimal risk of impact on a future contract with another authority. So you need to look at things like how you settle that, how it's described in the documentation, and try and resolve these things as best as possible. If we turn now to sort of the evaluation of the bids, Regulation 67 requires the sole basis for an award decision to be the most economically advantageous tender, known by the catchy acronym of MEET. The definition of MEET does include a lowest price option, which is probably really only suitable for the most straightforward procurements, along with a best price quality ratio approach. Award criteria mustn't have the effect of conferring an unrestricted freedom of choice on the authority. In addition, award criteria using MEET must be accompanied by specifications which allows the authority to verify the information submitted by bidders against the award criteria themselves. Weightings attached to award criteria must be communicated to suppliers in advance of the tender. If you're a bidder, you should really know how you're being scored, what are the criteria, what are the weightings. All award criteria must ensure the possibility of effective competition. It's been long established that award criteria cannot be used to favour a particular candidate or have the effect of breaching general treaty principles or distorting competition. There's a 2018 case of a Lancashire NHS Foundation Trust and a Lancashire County Council, where the court said, and I think this pretty much sums up what you should know, potential tenderers should be aware of all the elements to be taken into account by the contracting authority in identifying the economically most advantageous offer. So that's meat that we talked about, their relative importance when they prepare their tenders. So the court is saying you should have all this information to start with. Further criteria can form the basis of an award decision. Cost is now distinguished from price and is specifically mentioned as a permissible award criterion. Cost can include a cost effectiveness approach, and an assessment of life cycle costing is permitted. We're seeing more and more of life cycle costing, and really the purpose of life cycle costing is to allow greater strategic use of public procurement to further social and environmental objectives. It covers costs borne by the authority or other users, such as costs relating to acquisition, cost of use, such as things like the consumption of energy and other resources, maintenance costs, or end-of-life costs, such as collection and recycling costs. Costs also relate to environmental issues, provided the monetary value of these can be ascertained and verified. If an authority does want to go down this route of including life cycle costing when it's evaluating a tender, it must inform bidders in the procurement documents of the data they've got to provide, because it's very data-led, and the method by which the authority will determine the life cycle costs based on that data. And there are various calculation methods which are mandated by the EU. So you need to check in the tender documents what is being said about life cycle costing and make sure you follow that procedure and the calculation methods. Something that comes up a lot is bidders are unhappy with another bidder's pricing, thinking it's abnormally low, and the regulations clarify the position on abnormally low tenders. Regulation 69 obliges contracting authorities to demand that bidders explain the price or costs proposed in the tender where tenders appear to be abnormally low. A right to reject arises where the evidence supplied does not satisfactorily explain the low price. In addition, where a tender price is abnormally low due to a breach of the bidder's environmental, social or labour obligations, then the contracting authority is obliged to reject the tender. The regulations don't, though, provide a clear definition of what is an abnormally low bid, so one would have to look at the facts of the specific tender itself and review relevant case law. Where the regulations probably don't go into enough information, and there is some guidance from the government on this a bit, is where the overall price of, put forward by a bidder is not abnormally low, but one element of it is, for example, in relation to a particular product or service. And what we've seen a bit recently, and this is just my experience of it, my team's experience, is that people have been looking at the scoring and what scores apply to which criteria, and on a higher scoring element they have priced that at what might be abnormally low, and then sought to push up the price in another section which has a low score. So you might get a lower score where there are only a few points available, but a higher score where there are lots of points. And this is, to me, a bit gaming the system. It doesn't necessarily follow straight away, though, that that would be an abnormally low tender. So it's just something to bear in mind, and it's something, if you are the winning bidder being challenged, or vice versa, it's something to think about and to bring up from time to time with the authority itself. Once the authority has made its decision, the authority must issue a contract award notice to bidders as soon as possible. The notice must set out the award criteria, the reasons for its decision, including the characteristics and relative advantages of the successful tender, the scores the bidder obtained and those of the winning bidder, and government guidance states that this should include a breakdown of the scores against each criterion and sub-criterion supported by a narrative explanation. So it's not really enough just to say the winning bidder scored 5 points on this and you scored 3. They need to explain any sub-criterion within that, and they should give a narrative explanation. And my experience is that larger central government contracting authorities are getting much better at this and putting in detailed information, whereas sometimes local authorities can not provide as much information. And the less information provided, the more scope everyone has to potentially challenge it. You have to obviously say who the name of the winning bidder is and a precise statement when the contract standstill period is expected to be end. And so once that award notice has been issued, the standstill period begins. And this is a vitally important period during the procurement. During that standstill period, the contracting authority should not award the contract. And the period ends at midnight at the end of, if the notice is sent by fax, email or other electronic means, the 10th day after the day the authority sent the notice, or if it was sent by post or courier or other means, the 15th day after the day when the authority sent the notice. So, for example, if the authority sends the award decision notice on the 1st of July by email, then the standstill period ends at the end of midnight on the 11th of July. Most of the procurement I see now use some kind of procurement portal, bid portal, that would be within the electronic means, so that would be 10 days. A disgruntled bidder can get an automatic suspension of the contract award beyond that 10 or 15 day standstill period. An automatic suspension occurs when proceedings for breach of the procurement rules are issued and served on an authority before the contract is entered into. So you need to do it before the contract is awarded. The suspension remains in force until the court brings it to an end by an interim order, or the proceedings are determined, discontinued, or otherwise disposed. If a bidder is successful in obtaining an automatic suspension, then if they appear before the court to determine whether the suspension continues or is brought to an end by an interim order, it's quite likely that the court will require them to give a cross undertaking in damages. This will be to the authority and might also be to the winning bidder. Cross undertaking damages is a significant risk for the challenging bidder. They might be liable for all of the contracting authority's costs in defending the claim, to lifting the injunction, and if they are subsequently unsuccessful, it's likely that the winning bidder who they prevented entering into the contract will bring a claim for its loss of profits and its costs. So it's something definitely to bear in mind. The procedures for pursuing a procurement challenge are now helpfully set out in what's called Appendix H to the Technology and Construction Court Guide. It's pretty plain English. I really quite strongly recommend that you have a flick through this. It provides really useful information on how to bring a claim, how confidentiality is dealt with, how the court will expedite hearings in relation to procurement challenges, because they're well aware that they need to be dealt with quickly. What I suggest is I'll include a copy of that Appendix H along when I send around the slides. If a bidder does decide to pursue a claim for breach of the regulations, then there are specific limitation periods that apply to procurement, very different to the other sort of normal contractual tort limitation periods you might be aware of. Proceedings must be started within 30 days, beginning with the date when you first knew or ought to have known that grounds had arisen. So therefore, if you become aware of a problem during the procurement process itself, you need to consider whether to raise it as an issue then. What you don't want to do is, it's very obvious there was an issue, you leave it, the procurement goes on for some months, and you're outside the 30 days. If you bring it up then, there's a good chance that the contracting authority will turn around and go, well, you knew about it and you didn't do anything about it. This might also come out as part of the disclosure exercise. Court has the power to extend the time limit where it considers that there is good reason for doing so. It has to be a really good reason, to be honest. However, the court must not exercise its power to extend the 30-day time limit so as to permit proceedings to be started more than 3 months after the date you first knew or ought to have known that grounds for starting the proceedings had arisen. So you can have an extra couple of months potentially. As previously mentioned, proceedings are to be regarded as started when the claim form is issued. Where you do start the proceedings, you have to serve the claim form on the authority within 7 days after the date of issue. So really here, key is to have your procedures in place to spot procurement breaches and know how to escalate them internally. You've got really, think about, you've got under 30 days probably. Who are you going to report this issue to? On your contract team, do they know to report to the legal team? If it's the legal team, do they know who to speak to internally? Who has the authority to decide whether to proceed with a challenge? Challenges obviously can have a significant impact on a long-standing client relationship. We have seen sometimes quite clear breaches of the regulations. One team very keen to challenge, but in the big picture of the whole organisation, the senior management have decided not to challenge because they are going for other contracts at that point, which are much larger than the one that could be subject to the challenge. Obviously, a challenge shouldn't impact on whether you're successful or not on a separate challenge. They should be judged on their own merits. However, we all know commercially it can have an impact. If the bidder does decide to issue proceedings, then there are a number of remedies that might be available. These are an order to set aside a decision of the contracting authority in the course of a tender process. That's if you raise it early on. The award of damages to a bidder that has suffered loss or damage as a result of the breach, and a declaration of ineffectiveness, the effect of which is that prospective obligations under the contract are cancelled, or a financial penalty on the contracting authority. A financial penalty on the contracting authority is probably not very helpful to you if you're a bidder. So you're going to be looking for damages, you're going to be looking at the procurement run again, etc. If you are considering challenging an award, then I've got this little challenge checklist here, which I think it's just useful to have in your mind to sort of run through as soon as you see there might be an issue. So you've got the award decision notice. Does it set out the full award criteria, the reasons for the decision, including the characteristics and relative advantages of the successful tender, the scores you obtained and the winning bidder? So does it have that full breakdown of the scores against each of the criterion and sub-criterion, supported with narrative, the name of the winning bidder, and a precise statement of when the standstill period is expected to end? You can always ask for documents. You won't necessarily get them, but my experience is you're likely to get a fair amount of information. It also depends on how much detail the contracting authority has gone into in that narrative section when comparing your tender against the others. But I would especially ask for things like what guidance was given to those doing the marking. Were they given written guidance on that? Did they have training? I would ask for the scoring spreadsheets if you can get them. They will anonymize the names of the other parties, but there's no reason you shouldn't get that. And the reason for that really is that you should want to check the weightings that have been used by an authority. If they have said that this is worth X percentage of the overall score and X number of marks, check that in the actual mathematics, in the spreadsheet, in the formula, they've got that right. We've seen a number of times where our clients have been applying for a framework and they were 1 or 2% out, and then actually when you looked at how the weighting had been calculated in the spreadsheet, it was just wrong. Local authorities, in my experience, tend to be a little bit worse than this than central government, but that's just my day-to-day experience. But it's always worth having a quick look at that. Consider making a request under the Freedom of Information Act. You are entitled to a lot of information under that. That will usually take you well outside the 30-day time period, though, once you've actually got round to making the request. So it's sometimes more useful as a threat or once you've also issued proceedings. Under the old rules, under the 2006 regulations, you used to have you had this Alcatel standstill period, and you used to have a debrief meeting. You don't really have debrief meetings in the same kind of way, because all that information is now included, or should be included, in the award decision notice. But I would often suggest that you ask for a meeting with the contracting authority to go through why you're unhappy with how the procurement has been run or scored. That can be on a without prejudice basis if necessary, because you often get more information face to face about why you're unsuccessful, which can help you in a bid, and you can sometimes get across to them why you're particularly unhappy and you're willing to challenge, and you might be able to convince them that either part of the process needs to be run again, that you get added to a framework, or that the whole process gets restarted. Brexit, everyone's favourite subject. Well, at the moment at least, I think it's likely to have a limited impact on procurement law, at least really in the short term. The statutory instrument, the Public Procurement Amendment, etc. EU Exit Regulations 2019, ensure that the regulations will be repealed, but then immediately reenacted on largely the same terms. So that says to me that it's pretty similar. The differences for the time being should be marginal and really relate to the practical impact of being a third country. For example, UK contracting authorities will no longer be able to publish in the OJU, but will instead use a UK e-notification service, and financial thresholds will be stated to be in pound sterling, rather than in the euro. What is really less clear, though, is how Brexit will impact UK companies when they tender for EU procurements. A little bit out of the scope of today's webinar, but I know a lot of you, I can see down the list, will be doing work internationally, and particularly within the EU. The government's begun negotiations for the UK to be a party in its own right to the World Trade Organization's Government Procurement Agreement, known as GPA. We're part of that at the moment, but as a member of the EU. This would provide UK businesses with some access to the procurement markets of not only the 27 EU member states after we leave, but also the US, Japan, and 18 other countries worldwide. However, while membership of the GPA does open up procurement above certain value thresholds, it doesn't necessarily give the UK the same level of access we currently enjoy. What I suggest really is that you have a read of the Cabinet Office's procurement policy note titled "Preparing the UK for Leaving the EU." It's one of the many policy notes put out by the government, particularly on procurement. It's from March of this year, may well be updated again. What I'll do, like the other documents that I've mentioned, I'll include that with the pack. I also sit on the ACE's procurement subgroup, and we've been putting together a procurement guidance note, more on procurement generally, not challenges and the regs in particular, but it's about good procurement and procurement guidance. That's in draft at the moment, so hopefully that will be available in the next couple of months. I'm not sure when precisely that's going to be released. So really just key takeaways from today are for you to know which regulations apply, understand which ones. Is it the public contracts or utilities? There are other regulations out there in relation to things like defence. Just think about what they mean for your tender. Plan your tender in line with the evaluation criteria. Other people are, focusing on those high scoring areas. I suggest it's worth you doing the same sort of thing. Look at, what scores are available for different areas. Act quickly if there's a problem. You've got 30 days, beginning with the date when you first knew or ought to have known that grounds had arisen. Consider what remedy you're looking for. Are you looking to restart the whole procurement process? Are you looking to get added to a framework? Are you looking just for damages? Is it a declaration of ineffectiveness? For me, really, one of the most important ones is agree your internal procedures for challenging. Is it a business or legal decision? Who signs it off? What's the relationship with the client? You've got really short timescales here. You do need to get on with it, and we can often see, teams desperate to challenge because they are the incumbent on a project, and there's a large team already working on it or ready to. But from a larger commercial, for larger commercial reasons, it's decided not to challenge. And Brexit. I think at the moment it's likely to have a limited impact on the procurement rules as they are. But as time develops, and assuming we do leave at some point in the European Union, there will be further changes, I'm sure. And the government puts out lots of procurement notes. So hopefully we should have sufficient time to consider those and advise you on them. So thanks very much for listening. There are some questions that have appeared. It's taken about half an hour. What I suggest is I put together some of those questions and answers and add them to the pack. If there's anything else that you'd like to know or any other queries coming out today, I think my details should be on the following page. Yes, feel free to give me a call, drop me an email is probably the easiest with any questions. And I'll come back to you as soon as I can. If you are sending a question and you don't want that question and answer, obviously I'll make them all anonymous, but if you don't want that question and answer to be included, please just say so. And we're here to assist whenever you've got any queries. Thanks very much.